All right, everybody dumping D into the chat box, and that is correct. Exclusive right to sell guarantees or entitles the broker to a commission, regardless of who finds the seller. An exclusive agency agreement is where if the seller finds the buyer, that they then are not obligated to pay a commission. All right, question number 2. John and Mary are getting a divorce. John tells Mary that unless she agrees to sell the home immediately and split the proceeds, he will institute legal proceedings to gain custody of the children. If she agrees, the sales contract may be voidable because A, consideration, B, duress, C, offer and acceptance, or D, the legality of the object. All right, seeing all the B's in the chat box, that is correct. This would be a situation where duress would be a defense against the legality or the ability for this contract to be followed, since there was a threat to take custody of the children as a result. All right, question number 3, an option. A, keeps the offer open for a specified period of time. B, makes the seller liable for a commission. D or C, requires the optioner to complete the purchase if the optionee so elects. Or D, gives the optionee an easement on the property. What is an option? All right, a lot of C's in the chat box, and that is correct. This is an option is a unilateral agreement. So that's one important thing that you'll have to you'll remember that will likely come up is that one person gets to make a decision, and then it activates the contract. And so the optionee is the person with the option. The optionor is the person granting the option. All right, Melissa went to the dry cleaner and dropped off her wool goat to be cleaned. When the clerk accepted the coat, Melissa and the dry cleaning operation had just entered into what type of contract? A, executed, B, unilateral, C, implied, or D, complete? What type of contract is this? All right, seeing plenty of C's in the chat box. That is correct. An implied contract and his agreement that is not put into words or expressed. If it is put into words, either written or spoken, that is an express contract. But because she simply dropped off the coat with the expectation that it be dry cleaned by a dry cleaner, that is an implied contract. All right, Adam and Jenny enter into an agreement wherein Adam will buy Jenny's house at the asking price if Jenny will install a new roof, and if Adam can qualify for a loan sufficient to cover the purchase. Until the roof is installed and financing has been obtained, the contract is said to be A, voidable, B, executed, C, executory, or D, rescinded. What is the contract said to be prior to the roof being installed, prior to financing being obtained? All right, all C's in the chat box, and that is correct. This type of contract is one in which the parties have agreed to terms, but they still remain to be fulfilled. This would also be considered contingent. Those are the language you might hear and see in your real estate practice. All right, a commercial broker listed a storefront for rent. A tenant was procured, and after the lease was signed, the owner refused to pay. In order to obtain her fee, the broker could A, sue for specific performance, B, file a complaint with the Division of Real Estate, C, sue in criminal court because the fee was more than $30,000, or D, lien the property. Got some A's and some D's in there. All right, so let's talk about this one. Filing a complaint with the Division of Real Estate is not going to be an option because the client is the one who the complaint would be filed against. And that just means that, I mean, that's not going to go anywhere. The division is there for clients to file complaints against brokers or against agents. Suing in criminal court because the fee was $30,000. There's nothing in here that says that that's what the fee was. So you can throw that one out. So you're looking at lien the property or sue for specific performance. Sue for specific performance feels like it should be the right answer because we want the landlord to perform specifically by paying the fee, the commission for the lease. But specific performance, when you see that, that's related to land contracts, and that's that if at the end of a land contract or seller financing, as it's also known, the deed is not transferred to the buyer who is paid on that land contract or seller finance contract. So that is where specific performance shows up. So there is something called a broker lien that in the event only with commercial transactions or commercial leases can a lien be placed on a property to guarantee or ensure the payment of the necessary commission generated by leasing that property. So lien the property is the correct answer, but just know specific performance only applies to those land contract scenarios, and the liens on properties only apply to these commercial scenarios. All right. Seller Sam decides to purchase buyer Bob's home. He submits an offer stipulating that time is of the essence and that the offer must be accepted in writing before 12 o'clock noon, 3 days hence. On the third day at 11:30, buyer Bob telephones Seller Sam and says he's decided to accept the offer. Do the parties have a binding contract? A, yes, buyer Bob communicated the acceptance to Seller Sam. B, no, buyer Bob didn't wait until 12 noon. C, no, acceptance was not made in the manner specified. Or D, yes, Sam cannot revoke the offer. All right, C is going to be the correct answer here. Very important to read the question in detail. Accepted, offer must be accepted in writing, And so since Bob just called and said he would accept it, it is not per the terms of the offer and therefore cannot be accepted or is not considered accepted. A large mirror that a buyer wants to remain with a property should A, be verbally agreed upon with its stated price in the contract. B, never be included in the sales contract. C, be identified as a fixture in the sales contract. Or D, be regarded as having no consequence. All right. C is correct. It should be identified as a fixture if the client intends on it being included in the purchase. A listing agreement states that the property will be listed starting today and the listing will terminate upon the property being sold. Which statement is true? A, the buyer can determine when the listing will end. B, this listing is invalid as does not contain a definite date of expiration. C, when the property sells, the broker will be due a commission. Or D, the listing will lapse within a reasonable time. All right, guys, see, we're a little bit all over the place with this one, but a listing must have a definite date of expiration or it cannot be valid. Otherwise, we would just go get listing paperwork signed with every house that we could, and we would have all the inventory on the market, right? Or all the inventory that could ever be on the market. There has to be a definite ending date, date of expiration included in the listing agreement. Question number 10, a contract is entered into on fraudulent terms introduced by the seller. Upon discovery of the fraud by the buyer, the contract would be A, voidable by the buyer, B, void, C, valid, or D, voidable by the seller. All right, so anytime that there is a contract and there is either fraudulent terms or one of the parties has, is it some sort of disadvantage, you would say that the injured party, it has the right to void the contract, but does not have to void the contract. So that makes it voidable, right? And in this case, the fraudulent terms were introduced by the seller, which makes the buyer the injured party, meaning that this property is voidable by the buyer. So the fraud has taken place against the buyer, and so they would have the choice to void it, or if they chose not to, they could follow through. A seller signs an exclusive agency agreement with a broker. And the day the listing is signed, the seller's brother-in-law makes an offer on the property without knowing that the property has been listed. Which statement is true? A, the buyer will have to pay a commission. B, since the buyer was found during the listing period, the broker will be entitled to commission. C, the broker is not entitled to commission. Or D, the seller will have to pay a commission to the broker. All right, the answer to this one's C. So glad that everyone got that. The other thing that you can do on a question like this on your exam, and this just goes to like general test prep information for you guys. But as you work through the exam, you're going to see where multiple answers to one question say the same thing. Buyer will have to pay a commission. Broker will be entitled to a commission. Like those effectively say the same thing. Broker entitled to a commission, seller will have to pay a commission. Those effectively say the same thing. Buyers don't pay commissions, sellers do, and it's shared with the buyer's agent. So there are a few things in here that would tip you off, but ultimately the exclusive agency agreement is the one that if the buyer is found by the seller, they're not obligated to, they're not obligated to pay a commission. Question number 12, who is authorized to rescind a voidable contract? All right, so this is the same question as we had before, just said a different way. Neither party, only a void contract may be rescinded. The agent and the seller only. C, either party, or D, only the minor. And I apologize in advance. This is a little bit poorly worded from an answer standpoint with respect to, you have to understand that minors cannot enter into contracts and they would be considered an injured party. So with that information, all right. Again, a little bit of a weirdly worded question. I believe the answer should be D. And that's because a minor can't enter into a contract, but if they do, the contract is still only voidable because they would technically be the injured party or the party at a disadvantage. So they can rescind it, void it, but do not necessarily have to. So like I said, that's a little bit of a crappy question. You'll get better ones on the exam. A seller signs a listing agreement that commences today and ends December 31st. The listing agent tries as hard as possible, but cannot find a buyer who is interested in the property. After the first of the year, the listing is terminated by A, seller rescission, B, expiration, C, unilateral agreement, or D, statute of fraud. What is the function that eliminates or terminates this contract, and it is expiration. As we talked about, there must be an expiration date, and when it is passed, the listing is terminated. Seller Joe's agent personally delivers Mary's offer to buy his house. Joe said he would like to think about it for a couple days. Later that week, without making a single change to the contract, Joe decided to accept Mary's offer and signed it. He then addressed it to Mary and went to the post office and mailed it. Is the contract binding for both parties? A, yes, because Joe sent it in the mail. B, yes, because all it required was Joe's signature. C, no, because Mary has not received it from her agent. Or D, no, because Joe did not give it back to his agent. All right, so this is one of those questions where I can all but guarantee that you will have some question related to the mailbox rule when you take your exam. It's similar to, I can guarantee you that one question on the exam will require you to know that there's 43,560 square feet in an acre. So, you need to know that, and you need to know about the mailbox rule, which is as soon as it's in the mail, then it is determined that acceptance has been communicated, right? And that's the important thing, because it doesn't just require Joe's signature, it requires the communication that the offer has been accepted so that it can be enforced. All right, in face-to-face meeting, a farmer asks a roofer to install a roof on his barn for $1,500. The roofer says, I'll do it tomorrow. What type of contract do they have? A, unilateral, B, option, C, voidable, or D, express? D is correct. It is an express contract. It was spoken, could also be written or expressed. The terms were expressed, not implied. All right, gang. Let's see what else we wanted to cover tonight. Let's get back to this dashboard. I heard financing from someone and law from another. So if we could clarify, do we want license law or agency law? If you can just drop that in the chat. In the meantime, we will dive into financing. I think this should be a quick section. Should be able to get through this one and at least one more today. All right, if a property generates a gross rent income of $200,000 and a sale price of $3 million, what is the gross rent multiplier? Is it A, 18, B, 25, C, 30, or D, 15? What is the gross rent multiplier? All right, it's pretty straightforward, guys. Take the sales price, divide it by the gross rental income, and that's going to give you your multiplier. What would you have to multiply it by to get to 3 million? It's 15. All right, a type of financing available for real estate mortgages in which a percentage of the interest rate will differ from year to year according to terms specified by the lender is known as an A, adjustable rate mortgage, B, fixed rate mortgage, C, fluctuating loan, or D, amortized loan. All right, seeing some A's in the chat box. That's going to be right. It is adjustable rate. There's no such thing as a fluctuating loan. A fixed rate mortgage is the opposite of an adjustable rate mortgage, where you know it's fixed rate. And an amortized loan is one where you pay a portion of the principal and interest every month always paying the same amount for a period of time until the loan is paid off on the last payment. All right, the seller must have $140,000 to pay off a mortgage, $15,000 for a vacation, $15,000 in closing costs, and the broker fee of 70% or 7%. How much must the property sell for? Is it A, 181,850? Is it B, 179, 181? C, 182, 795, or D, 175, 250? And if you guys, if you don't know how to do a certain problem, or you don't know where to go, or you just don't know the answer, drop a question mark in the chat box. That way I can, on some of these problems, I know that it can be, there's some math involved, and sometimes that's a little intimidating. So just want to make sure that we get everyone the explanations that they're looking for. All right, so let me go ahead and work this one out. The first thing we want to do is add up all of the monies that will be needed. So there's 140,000. Get my bar out of the way. 140,000 for paying off the mortgage, 15,000 for the vacation, plus 15,000 for the closing costs. So there's 170,000 that is needed here after the broker fee of 7%, right? And so if we take 170,000 and divide it by 0.93, right? So we want our 100% to leave us 170,000 after we pay the 7. So we take 100%, we subtract 7 from it, so it's 0.93, and then we divide by that. And that gets you 182, 795, 70, right? And that should be the correct answer. Now that's the correct way to calculate the 7%. Now what folks can do, and I think some of the folks who put A in the chat box did, is you get to 170,000 and then you multiply it by 1.07 to get to, you're like, oh, that's how I'll give myself that other 7%. And you're close enough with 181,900. But the thing is, if I multiply this by 0.07, right? So 12,733. So then I'll go 181,900 minus 12,733. And you'll see that, oh shit. What was that? 181,900 minus 12,733. I actually end up with less than the amount required. So a good way to check your math backwards and forwards is to just work the question back down to 0, right? But whenever you're trying to calculate how much you will need to cover a commission rate, you want to subtract that commission rate from 1 and then divide by that amount, and that'll get you to where you need to be. The provision on a promissory note or mortgage that calls for the entire amount of the unpaid balance to be due upon the happening of a certain event is known as a Habendum Clause, an incohate clause, an indemnification clause, or an acceleration clause. Acceleration clause is correct. So what are these other ones? An incoherent clause is refers to an incomplete interest, such as a person's dower interest during the lifetime of the owning spouse. A habendum clause refers to the clause often included after a granting clause in many deeds, beginning with to have and to hold, describing the type of estate granted. Indemnification refers to a personal guarantee to hold a person harmless from any further liability. For example, an insurance company indemnifies the insured against a loss or flaw in the title. Acceleration is speeding it up, bring it all forward. And there are a few events that will typically do that from a mortgage standpoint. Transfer is the most common. If you sell a property, they will make the mortgage due immediately. And that's typically okay because you're getting a lump sum or there's another mortgage replacing you from the buy side. Disintermediation refers to A, transferring real property by a private owner to a public agency, B, an instrument used in many states in place of a mortgage, C, representing both parties in a transaction, or D, the movement of money out of a savings account into a higher yield investment. All right, what do we have here? Looks like a whole mess of D's in the chat box, and that is correct. A deed of trust is the instrument used in many states in place of a mortgage. Dedication is the transfer of real properties to public agencies. Disintermediation is the movement of the money. Dual agency is the act of representing both parties. An additional loan fee charged by lenders to make the yield on lower than market interest rate loans competitive with higher interest conventional loans is called A, debt service, B, a discount point, C, debt, or D, disintermediation. All right, seeing enough B's in the chat box, we'll go with that, and that is correct. We already know what disintermediation is. Debt service is paying your debts on a regular interval to reduce it. Debt's the amount of money owed, and discount point is the additional fee charged by the lender to make the yield on the lower than market interest rates competitive with the balance. All right, a buyer is late with his monthly mortgage. The lender could declare the entire loan, unpaid loan amount due immediately under which clause? A, acknowledgement, B, hypothecation, C, accretion, or D, D, acceleration. Acceleration, as we went over, is correct. That will be the case. The acceleration clauses, as I said, typically happen with transfer, but they can also happen with default as well. All right, an investor decides to make money out of take money out of a savings account, invest in a high return corporate security. This movement is known as, we've already been over this one, disintermediation. All right, question number 9. A lender charges 3 discount points on a loan. The buyer is buying a $100,000 home and getting an 80% mortgage. How much will the discount points, how much in discount points would the borrower be required to pay? A, $2,500, B, $3,000, C, $6,000, or D, $2,400? 3 discount points. 3 discount points. So discount points are only due or are only calculated on the amount of the loan. The amount of the loan. So in this case, an 80% mortgage means it's an $80,000 loan. So a discount point is 1% in this situation. 1% of $80,000 is 800. 800 times 3 is 2,400. So very important that when you're working with discount points, you make sure that you calculate the loan amount first, not just the total purchase price of the home. All right, a lender wishes to make the yield on a lower than market interest rate loan competitive with the higher interest conventional loans. Sorry, this is the same question again. They would charge discount points to make that make sense. All right, gang. We've got time for at least one more here. Let's go ahead and we can go into broker relationships or agency law. I know that was one of the ones requested. All right. A broker lists a property that he owns personally. One of his sales agents produces a buyer for the property. What must the broker do to avoid becoming a dual agent? A, treat the buyer as a customer. B, act as a split agent. C, be a sub-agent. D, be a dual agent. All right, looks like A is our preferred answer, and that is right. Treat the buyer as a customer, right? If the broker does not want to be dual agent, to avoid that, one of the parties has to be the client, and the other is a customer, so that they are in effect representing themselves. All right, a sales agent is interested in buying some property. The sales agent walks through the seller's house, but does not mention being a sales agent. What is true? A, the sales agent has not violated any laws. B, the sales agent is not allowed to buy the property without his broker being involved. C, the sales agent has violated the fiduciary duty owed to the seller. Or D, the sales agent must disclose during the walkthrough the fact that the sales agent is buying property for his own purposes. All right, couple A's, a few D's. Let's let a couple other people answer. Well, it seems like the group's pretty confident it's either A or D. So we don't know that the agent is buying the property, right? There's no offer written. And so what this one should be A, I believe. And the reason for that is that you can walk through properties. You can go view homes without disclosing that you're a realtor. But when you write the offer is when it should be required. It is required that you disclose that you're a real estate agent. You do not have to disclose that while touring or viewing a property. If you are selling a property, you must disclose outright in any advertisements or any communication, including the sign in the front yard, that it is a agent-owned property or that the seller is a licensed real estate agent. That should be disclosed everywhere. But the disclosure is not required on the buy side until the time of the offer being written. Which would cause a real estate agent to lose his Ohio state license? A, violation of the Board of Realtors Code of Professional Responsibility. B, a minor traffic violation. C, violation of the Code of Ethics. Or D, a violation of the Canon of Ethics. All right, D's are correct, and that is because canons can hurt you, codes can't. That's the easiest way to remember that. The Canon of Ethics is from the Ohio Real Estate Commission. The Board of Realtors and the National Association of Realtors have codes of ethics or codes of professional responsibility. The Ohio Real Estate Commission is one of the groups that can impact your license, and they have the Canon of Ethics. A broker takes a listing on a property. The seller states that if necessary, they are willing to accept an offer $5,000 less than the listing price. What is the obligation of the broker to the buyer? A, the broker owes fiduciary duty to the buyer. B, the broker must disclose to the buyer that the seller is willing to come down $5,000. C, the broker has no duty whatsoever to the buyer. Or D, the broker may not disclose what the seller said about the price reduction. All right, D's filling the chat box, and that is correct. Those statements must be held in confidence unless the seller instructs him to communicate that. The duties of honesty and fairness exist for customers, which in this case the buyer would be. But beyond that, there is no fiduciary duty or duty of confidentiality due to the buyer. All right, what is not the unauthorized practice of law? Is it A, preparing a real estate contract, land contract? B, completing a pre-printed sales contract form? C, preparing a real estate lease? Or D, preparing a real estate sales contract? Which one of these is not unauthorized practice of law? All right, guys. So preparing, read preparing as creating, right? You as a real estate agent cannot create contracts or leases for that matter, as they are documents that have to be completed by lawyers. And the one thing that you can do that would not be unauthorized practice of law for a real estate agent is completing the pre-printed sales contract form. So our brokerage, along with every other, there are, several pages, lots of fill in the blank, and then you fill in the blanks. But the contract itself is, a pre-printed form with everything lined out from a legalese standpoint. But anything else, creating land contracts, creating leases, you are not permitted to do. And that would be unauthorized practice of law and would cost you your license potentially. A sales agent is taking a buyer through a home. The sales agent has not viewed the basement. When asked about the condition of the basement, the sales agent says, the basement is completely dry. What is true? A, the sales agent is guilty of misrepresentation. B, the sales agent has made no misrepresentation. C, the sales agent is guilty of fraud. Or D, the sales agent is guilty of caveat emptor. All right, the A's have it. Misrepresentation is going to be what took place here, which is negligence on the part of the agent. If they knew the basement was wet and said it was dry, that's an intentional lie and is therefore fraud. In this case, they did not know, they did not intentionally lie. They truly didn't know whether or not the basement was in good condition, and they just misrepresented it. A sales agent advertises a property, advertises a property for $180,000 when in fact the sales agent listed the property at $200,000. The sales agent does not have the seller's permission for the property to advertise the property at $180,000. What statement is true? A, the sales agent has committed no wrong. B, the sales agent is guilty in violating a Truth in Lending Act. C, the sales agent is guilty of false representations. Or D, the sales agent is in violation of the Real Estate Settlement Procedures Act. All right, C is correct. Guilty of false representation, or bait and switch, as they say. Truth in Lending Act does not apply here because there's no lending involved, and the RESPA, Real Estate Settlement Procedures Act, is about what things have to be disclosed at the end of the transaction at the time of closing. All right, all right. Question number 8, salesperson A knew that Mr. and Mrs. Buyer were working with salesperson B under an exclusive purchaser agreement. Before A can work with the buyers, he, A, may not work with the buyers until the broker's protection clause in the buyer-broker agreement expires. B should ask B's broker when the agreement expires and wait until it does before contacting the buyers. C may contact the buyers after B has not contacted them for 7 days in a row because this constitutes abandonment. Or D should contact the buyers right away because the case study has proven that broker agreements do not hold up in court. Seeing a couple B's in the chat box. And that's correct. Abandonment isn't determined by a specific number of days. And because the contract is with the broker, not with agent B, then that's who needs to be contacted regarding the expiration timeline for that contract, which, similar to a listing agreement, there is requirement of expiration dates on buyer broker agreements. All right, question number 9. What is an ethical standard that must be followed by an Ohio real estate sales associate? A, treat all people with honor and dignity. B, treat all people as though you would have them treat you. C, treat all people honestly and fairly. Or D, treat both buyer and seller equally. So what duties are owed to every person we interact with as a real estate sales associate? It is C, treat all people honestly and fairly. Question number 10, what duties are owed to a third party involved in a real estate transaction? That's just the same question asked another way. Honesty and fairness due to everybody. All right, a licensed sales agent is contemplating selling her own property. What must the agent do to comply with the Ohio law? A, disclose the type of agency being offered. B, disclose that the listing agent in the listing that she is a sales agent. C, disclose in any advertisement that the property is being sold for sale by owner by an owner agent. D, disclose the type of lending being offered. Now, remember, when we talked about this as from the sell side, it has to be disclosed everywhere. Everywhere. So all of the advertisements need to say, this is being sold by a licensed real estate agent. Yes, it needs to be disclosed in the listing. It also needs to be disclosed on the sign. It also needs to be disclosed on the advertisement you put in the paper. It needs to be disclosed online. It needs to be disclosed everywhere. So B is correct. It does need to be disclosed in the listing. However, that is not inclusive or all encompassing as C is. Question number 12. Consumer guide to agency relationships form must be provided for all of this following except a two-family come on in. A two-family residence, a single-family residence. Okay, awesome, thanks. An office building or a condominium. Which one does not need to be provided? Does the consumer guide to agency not need to be provided? Seeing a lot of C's. That is, excuse me, correct. Consumer guide to agency must be executed for residential real estate transactions, but is not required for commercial property. We do require that with all of the transactions in our office, but it is not required by the state. All right, we'll do one more question, guys, and then my appointment is actually here early, so I'm going to have to step out for that. So last question for the night here. A sales agent is found guilty of a violation of the Ohio Revised Code involving non-disclosure of an agency relationship. What is the liability of the agent? A, the revocation of the sales agent's license. B, jail term not to exceed 30 days. C, criminal penalty for 4th-degree misdemeanor. Or D, a fine not to exceed $2,500 per violation. All right, seeing a couple D's. There's a whole slew of D's, and that's correct. You can fine the agent up to $2,500 or suspend the sales agent's license. Revocation of the agent's license would not be immediate. There is no criminal charge for any of this either. So there you have it. All right, guys. So thank you so much for joining us this week. I'm going to put my my email and phone number in the chat. If you could, please make sure we know if you are testing in the month of December. We want to make sure you guys get all the help that you need for that as you work your way towards that exam, and also make sure that we have we know when you guys are testing so we can send you some love and make sure that you again have everything you need prior to that exam. So go ahead and shoot me an email. LaShawn, good luck taking it tomorrow. Fingers are crossed for you, man. And then if we have anyone else taking it, just shoot me an email or shoot me a text. And then we will be back here Monday with full bellies after Thanksgiving. So everyone have a wonderful Thanksgiving. Enjoy yourself. And we will see you in 7 days' time. Thanks so much, gang.